Hello, my name is Maartje van Eerd and in this video we are going to talk about the importance of the incorporation of international housing rights in national constitutions. Why do we need to know about the so-called domestication of housing rights? Housing rights deal with obligations of states towards individuals. It is very important that citizens as well as policymakers are aware that housing is a right, that governments have the duty to do everything within their means to progressively realize that right, and that citizens have the right to seek redress from courts of law for violation of their right to adequate housing. The right to adequate housing was incorporated in the International Covenant on Economic, Social and Cultural Rights of 1966. At this point in time, it has been ratified in almost every country around the world. Ratification means that states have a duty to respect the housing found by people themselves by abstaining from forced evictions and displacement. They must protect the tenure of existing housing against interference or unjustified evictions by third parties and adopt and enforce the necessary regulations to ensure the necessary quality of housing. They have the obligation through regulatory functions to facilitate the opportunity of everyone to find affordable housing, and in exceptional circumstances and regarding particularly vulnerable groups, they have to provide necessary housing when individuals or groups cannot manage to do so themselves. The obligation is such that governments must demonstrate that the measures they take are sufficient to realize the right for every individual in the shortest time possible in accordance with the maximum of available resources. According to UN Habitat, legislative actions and advocacy towards the realization of the right to adequate housing are ensured when constitutional rights to adequate housing are established. However, the extent to which this right is enshrined can either be as a justiciable or a non-justiciable right. When non-justiciable, it means that the realization is considered as a mere political obligation, but not enforceable in court. Housing rights and activists play an important role in demanding the right to adequate housing to be realized by their respective governments. I'm here together with Faith Ndlovu, an alumni from IHS, Edward Molopi from Syria in South Africa, and Vanessa Peter from India to discuss the importance of the justiciability of housing rights in the two countries and to what extent that supports or hampers their work.
The Constitution of South Africa recognizes the right to adequate housing as a justiciable right. Article 26, 1 and 2 of the South African Constitution contains provisions which mirror Article 11 of the International Covenant on Economic, Social and Cultural Rights. This article recognizes and holds justiciable the right to adequate housing for all, calling for progressive realization of adequate housing and prohibits forced evictions and demolitions. Thus, citizens have the right to seek redress from courts of law for violation of their right to adequate housing, which can manifest in forms such as forced evictions. In India, the right to adequate housing is not included in the Constitution, but the Supreme Court and state high courts in several important court judgments have clearly established the relation between the right to housing and both the right to residence, Article 19, 1E, and the right to life, under Article 21.
We will now explore the two cases to see how the fact that the right to housing is anchored as a justiciable right in the Constitution or not impacts the work of NGOs and housing rights activists to demand the realization of that right. Hi, Edward and Vanessa. Can you tell us in short what your organization does in the field of housing?
I'm Edward Molopi and I work for SERI. SERI works to ensure that poor and vulnerable people have access to tenure and adequate housing, water, electricity, and sanitation. We've been at the forefront of efforts to prevent evictions which lead to homelessness, to press for in situ upgrading of informal settlement, and to prevent unfair water and electricity disconnections. SERI also works to protect the rights of residential tenants and to prevent unfair banking practices which may result in the loss of a home.
Peter, founder of Information and Resource Center for the Deprived Urban Communities. IRCDUC has evolved as a community-centric information hub to enhance the capacities of communities, facilitate community-led initiatives, disseminate information about laws and policies, and undertake policy research to land and housing. IRCDUC has been working in the cities of Chennai and Madurai since 2011 in nearly 67 settlements with the help of our volunteers. These inspiring volunteers have enabled us to reach out to the most vulnerable communities by addressing the disconnect between the people and the policymakers to ensure that the most vulnerable sections can assert for their right to adequate housing and access basic entitlements.
And how important is it that the right to adequate housing is a justiciable right in the Constitution of South Africa?
The right of access to adequate housing is undoubtedly one of the most fiercely contested and frequently litigated socioeconomic rights in the South African context. This has led to the development of a wealth of jurisprudence, progressive jurisprudence in respect of housing and eviction law, which would not have been possible if the right was not justiciable.
In India, the right to adequate housing is not included as a justiciable right in the Constitution. How does that hamper your work, Vanessa?
One of the key challenges that the civil society organizations face in the country is the lack of legal and policy safeguards on adequate housing and protections from arbitrary evictions. This happens because housing is not recognized as a justiciable right in the Constitution. Therefore, access to justice for communities seems to be a distant dream because they often fall victims to arbitrary eviction process and inadequate resettlement. This has forced IRCDUC as an organization to demand for policy and legal and policy safeguards. And we have been demanding for this by undertaking a lot of policy participatory action researches. And through our advocacy in Tamil Nadu, we were able to advocate for a housing and habitat policy, and the government is in the process of drafting a rehabilitation and resettlement policy. However, evolving a participatory legal and policy making process continues to be a challenge because of the voice of the vulnerable communities are often silenced.
How does this help your organization to demand that right to be realized?
Through the use of litigation, SERI assisted over 80,000 people to resist unlawful eviction from their homes in informal settlements, private homes, and also in inner city buildings. SERI's ongoing work remains essential to support low-income households in their efforts to resist evictions and displacement as a result of urban regeneration processes and gentrification. And we also promote informal settlement upgrading across the country.
And would it help your organization in demanding that right to be realized if it would become justiciable, and why?
If housing continues to be challenged as it is not a justiciable right, and states do not have adequate legal and policy safeguards in place to protect the communities. So access to justice will be only realized when there are adequate legal safeguards. So towards working to this, as IRCDUC, we have been working towards translating the relevant laws and policies in the vernacular language so that the communities will have access to information. And the community leaders in the communities are now able to access their basic rights and entitlements because of this access to information. And with housing being recognized as a right and not merely a program or a scheme, the vulnerable communities will be able to demand for it, as currently housing is seen more as a charity.
And how important is an independent judiciary system in this respect?
The independence of the judiciary is the cornerstone of a democratic society and safeguard for the freedom and rights of the citizens under the rule of law. It is extremely important for the judges to be free to make impartial decisions based solely on the law and facts without interference, pressure, or influence.
And it is very important that there is an independent judiciary system to undertake periodic legal reviews to strengthen the existing legislations. In Tamil Nadu, some of the critical legislations related to informal settlements and housing has been redundant and not being implemented. Therefore, there is a need for strengthening the existing legislations and formulating new ones to ensure that the rights of the vulnerable communities are safeguarded.
Thanks to both of you for showing the importance of the incorporation of housing rights as a justiciable right in the Constitution, and all the best with your work.